Hello, everyone. We bring to you this podcast on SEBI's recent consultation paper on its draft framework for online platforms to be recognized as specified digital platforms. Recently, the Indian Securities and Commodities Market Regulator, which is known as SEBI, issued a circular draft framework which proposes to curb unregistered financial influencers, or what we generally refer to as fin-fluencers colloquially, from posting content or advertisements on social media platforms, which may sway followers into making misinformed and risky investments. Now, SEBI has observed that these influencers engage in practices that generally lure the public into investing in the stock market. Sometimes they may be branded as educational courses. Sometimes it may be casual content posted in the form of reels, videos, posts, stories, written posts, blogs, so on and so forth. It may or may not generate income for the influencers. It may or may not be sponsored in the back end by various brands, various investment related houses or companies. But ultimately, this kind of content, especially in the last couple of years, since COVID, has widespread reach in terms of reaching the Indian public. And SEBI has taken note of this and has recently undertaken various measures to clamp down on this, to protect members of the public from being swayed into these kind of risky investments, which in certain cases may be misinformed, misrepresented. As I said, some of them may be sponsored in the back end, may not provide necessary information and related risks to the users, right? And members of the public often act on this advice, and some of them turn out to be risky investments. So the circular was issued very recently. It's called the consultation paper on the draft circular for specified digital platforms. It was issued on October 22nd, and comments were invited till November 26th. And that was after an extension as well. We as a firm submitted our comments on the draft circular and also published a hotline on this a couple of days ago. Both are accessible on our website. Essentially, just to take a step back, this follows SEBI's recent actions as well over the last couple of years to address the risks. There was, for instance, an earlier consultation paper of Association of SEBI-registered intermediaries or regulated entities with unregistered entities, including influencers. This basically aimed to address the risks posed by unregistered and unauthorized investment advisors and research analysis, what we generally refer to as IAs and RAs, right? Or unregistered influencers who influence investor decisions and promote various forms of securities and investments, often for undisclosed, financial benefits or compensation, right? There's also certain advertisement-related restrictions where the publication of misleading or deceptive testimonials or misleading statements by various individuals are barred from publication. And recently in August, SEBI also amended 3 regulations, with prohibiting, various SEBI-regulated entities like stock exchanges, clearing corporations, registered depositories, agents from associating, with various forms of, unregistered securities advisors, persons generally not authorized to make various claims or advertisements pertaining to investments, so on and so forth. So just, putting it into a capsule, SEBI has clamped down on its own registered entities, regulated entities, as I mentioned, like stock exchanges, clearing corporations, so on and so forth, from associating with these platforms that may promote or host content by unregistered individuals or influencers with financial advice. This is a first we are seeing where SEBI is now acting or enforcing this through the platforms, where it's asking the platforms to implement certain measures, and only if they do so can they come forward and be recognized as an SDP And only if they're an SDP can the actual SEBI regulated entities like the exchanges, clearing corporations, depository agents, and all of that actually associate with the platform for said financial advice, right? There are various issues that arise with this circular. One being a potential conflict with the existing regulatory framework for online platforms and intermediaries, which we'll get into. Another being, a potential curtailing of the freedom of speech, guaranteed under the Constitution of India, overlap with other interministerial efforts by the government. We've broken this down into these issues, which we will do a small deep dive in. I have my colleagues here to unpack some of these points. Pradyumn, Palak, and Pradyumn, all members of the firm's technology, media, telecommunications practice. So without any, further ado, now that we have background, where SEBI is coming from, what they're proposing to do, let's get directly into the circular in terms of what it means for the intermediaries, what it's asking them to do. We'll start with that and, hand over to Pradyumn. So Pradyumn, could you give us an overview of the circular? What does the circular actually say? What does the circular prescribe? What does it mean, for the online platforms? What does it ask them to do? And what is the benefit of them doing that?
Thank you so much, Aaron. So as you correctly pointed, the circular aims to address the growing concerns about fin-fluencers and their involvement in misleading and misrepresentative practices. And in order to do so, the circular specifies certain measures and compliance requirement that SDPs must fulfill to get recognition. And only once they get this recognition, they are allowed to establish any sort of association with SEBI regulated entities such as stock exchanges, clearing corporation, deposits, and etc. So the circular envisages a preventive measure and a curative measure. The preventive measure aims to prevent any fraud, impersonation, unauthorized claim, and presence of unregistered entities. And in order to do so, they need to comply with certain prescriptions that are provided within the circular. The first is that they need to establish a policy to share any aggregated or securities related data on the platform with SEBI. The second is that they need to rely on technical tools, specifically AI and machine learning tools, to identify and analyze securities related content on their platform and assess whether they are in violation of SEBI regulations. Third is that they need to implement auto-check mechanisms to verify intermediary or entities recognition with SEBI. Fourth is that they need to create a policy to take action to address fraud, impersonation, unregistered activities. And finally, they need to take strict measures against any form of impersonation of SEBI officials and any regulated entities. In an event where the preventive measures are not able to address the lacuna on the platform, the circular also prescribes curative measures, and the platform need to comply with 3 broad curative measures. The first is that they need to establish a policy and system to analyze any content which is in violation of SEBI's guidelines by using AI and ML tools. Second is that they need to set up a reporting or escalation channel for any unlawful content or advertisement, and this should be accessible to SEBI regulated persons and any platform user. Third is that they need to implement procedures to respond and report any sort of content or advertisement within a specific turnaround time. This should be done by either taking down the content, blocking it, preventing it from being further disseminated, and finally, if such a user is continuously sharing and disseminating such content, by blacklisting a repeated offender.
Thank you, Pradyumn. That was quite exhaustive. So clearly there are quite a few compliances, both on the preventive and curative side, that have been prescribed for these, so-called SDPs, to take in order to get their status and maintain their status as such platforms. Moving on to Rhythm, we'll now discuss what issues, such measures may bring about, in terms of potential conflict with existing framework. Is it sufficient? Do we already have a regime in place? Is there a potential overlap or conflict, or is everything harmonious? So Rhythm, could you throw some light on this, please?
Sure, Aaron. Thank you. So before we delve into some challenges or potential issues that the proposed SDP circular may pose, I want to highlight that it does seek to protect investors, which is a positive step by SEBI. So now one of the main issues with the proposed circular is the significant regulatory overlap. The primary problem that this SDP circular seeks to curb is related to the online content posted on online platforms. So let's keep these two keywords in mind: online content and online platforms. Now, there exist a lot of regulations which, specifically focus on online content as well as these online platforms where such content is posted. I'll just highlight a couple of these for our listeners. So the MIB, which is the Nodal Ministry for Information and Broadcasting, timely issues various advisories advising social media intermediaries, which are essentially online platforms, against the content which has potential to mislead the viewers. Similarly, the Ministry of Electronics and IT, through the IT Act, has brought forth a punishment for cheating by impersonation by using a computer resource. This provision of the IT Act essentially prohibits any content published on social media platforms or online platforms wherein an individual may be personating an IA or an RA and providing financial advice. Through the Intermediary Guidelines 2021, the Ministry of Electronics and IT also specifically regulates online platforms as well as online content. There are other ministries such as the Ministry of Home Affairs, which have also issued advisories warning against fake, stock market investment related applications and platforms. And these advisories also focus on spreading awareness about content related to financial advice. In addition to this, the misleading ad guidelines issued under Consumer Protection Act regulate online content as they provide detailed requirements for advertisements which may be posted on social media platforms. While there are some other regulations I could talk about, I will just quickly touch upon the primary criminal law in India and move on. So even the Bharatiya Nyaya Sanhita prohibits acts such as personation and cheating, in turn prohibiting publishing online content on online platforms, where individuals may be posting financial advice by pretending to be IAs and RAs. So in light of this significant regulatory overlap, there is a huge possibility that the implementation of the SDP circular would lead to confusion about which law or regulatory body takes precedence, in turn leading to compliance challenges for the specified digital platforms. Now, moving on, another challenge that may be posed could be posed due to mandatory use of AI and machine learning tools, which has been provided in the circular as part of preventive measures. Now, while AI can be incredibly powerful, we know it is not perfect yet. So these AI tools and systems can produce errors or lead to technical limitations, often requiring human intervention. So this mandatory reliance on these AI tools and systems may pose further challenges for platforms, and content analysis and monitoring may end up becoming more cumbersome because of this. Further, keeping in mind smaller entities with limited resources, I think it is important to note that it may not be practically and financially feasible for such entities to deploy these AI and machine learning tools on their platforms. In addition to this, one of the issues is the lack of clarity on the scope and meaning of the term specified digital platform in the circular. So the SDP circular does not define any thresholds for, which entities could qualify to be an SDP. And without this clarity, all platforms, regardless of their scale, size, number of users, and available resources, are lumped together under the same set of obligations. These mandatory obligations proposed by the circular might pose to be disproportionate for some smaller platforms with limited reach and visibility, as the level of harm caused may not be as high when content is posted on a smaller platform compared to the level of harm that the wrongful content posted on bigger platforms can potentially cause. Now, while we know that there are a few issues, we also know that investor protection is absolutely crucial. Hence, I would like to highlight again that the existing laws do not specifically seek to address misinformation related to securities market, and the circular does try to fill that gap. In light of the potential roadblocks which are highlighted that may be caused due to the SDP circular, one way forward could be for SEBI to collaborate with other relevant regulatory bodies to come up with a harmonized framework. This way, the issues about misinformation related to securities market can be addressed without overwhelming the platforms with overlapping compliance requirements or encouraging them to over-censor.
Thanks for that, Pradyumn. So clearly, there is some bit of friction that is created, with this proposed framework for the platforms to be recognized as SDPs with SEBI. We already have various initiatives and efforts by certain other industry regulators. We have certain jurisprudence on intermediary liability and safe harbor protection in terms of the role that they could perform and certain, limits or boundaries that they should not overstep. So there could be there is potential friction with these established principles and framework. Moving on to Palak, let's deep dive a little more into what is, the current legal framework, for the intermediary platforms, right? For instance, let's start with what is an intermediary? What is the role of an intermediary? What is the existing legal framework for an intermediary under the information technology laws? Right? And when can an intermediary claim safe harbor protection, which is essentially protection against liability for content that is hosted or transmitted through the intermediary platform? So let's unpack, this framework which is in existence for intermediaries and where there could be a potential conflict that the proposed SEBI STP circular brings about.
That's right, Aaron. I mean, there is a certain amount of limitation within which an intermediary can function. To give our listeners some context, an intermediary acts as a conduit between users who are using the intermediary's platform. Simply put, Aaron, you and I have an account on a social media platform and we can communicate with each other. The communication is facilitated by the intermediary's platform. As simple as that. Now, under the Information Technology Act, there is a particular section 79, which states that an intermediary's role is limited to providing access to a communication system over which information is made available or hosted by third parties such as you and I. Now, what is happening with the SDP circular is that the intermediary is going beyond its role from acting as a mere conduit between us users. It's reviewing the content. It is analyzing whether it is in tandem with the SEBI regulations, as Pradyumn had mentioned. So, the problem here is that an intermediary's role is being crossed. Under the IT Act, there's a reference that the intermediary has to abide by the due diligence requirements that are there. And these due diligence requirements are provided to us under the Information Technology Intermediary Guidelines and Digital Media Ethics Code Rules of 2021, for short, Intermediary Guidelines. Now, under this section, Rule 3(1)(b) specifically states the due diligence requirements that an intermediary needs to undertake to ensure that their safe harbor protection is being given to them. Here, what the intermediary needs to do is that they need to only take reasonable efforts to ensure that their platform is not displaying or uploading any information which, for example, impersonates another person or is harmful to a child or is deceiving or misleading the addressee about the origin of that particular information. Now, if we see this in comparison with the SDP circular, there are appropriate safeguards that are being deployed by an intermediary to get this safe harbor protection. The moment an intermediary starts to interfere with the kind of content that is being deployed on their platform, this safe harbor protection will get diluted. Moving on, if we just slip a little bit into the depth of what these due diligence requirements are for the intermediaries under the intermediary guidelines, one of them is that they have to remove content which impersonates another person. They have to take reasonable effort that this is not on their platform, or any information that is patently misleading or false. Now, if this is already being covered, the requirement under the SDP circular may be infringing on an already existing requirement, which could dilute their protection. Just adding a little bit on how this framework already works is that if a user makes a complaint about certain content to be taken down, the intermediary is obligated to take that content down within 15 days or take some action to resolve it within 15 days. In comparison, the SDP circular does not provide so much of time. It is, I think, limited only to 24 hours to take such action. So, yeah, I mean, that I think is a big problem for intermediaries at the moment.
Thanks, Palak. So clearly we have some work, cut out in terms of, what SEBI, should take back. I'm sure a lot of this feedback, has been submitted in terms of, various comments, though they have not been put online. It has been part of some of the stakeholder discussions that we have attended, some of the discussions we've had with, various parties, that could be subject to the regulations, the proposed regulations rather. So I think that's a good way forward in terms of aligning with other ministries, having a further consultation process, aligning the framework with existing laws so as to not conflict or dilute the safe harbor protection that's available to intermediaries. So I think, SEBI has a bit of work cut out for it, especially on this aspect, since it's choosing to clamp down and regulate financial advice of influencer content via the platform route, right? So this is good. This is informative. This is insightful. With that, we'll close this podcast. If anyone has any questions, feel free to reach out to Pradyumn, Palak, Hridayam, or I. Happy to discuss. Otherwise, we'll put an end to this. So thanks so much, to all of you for this. It's been a good recording, and we'll obviously keep an eye out on any further developments on the space. Thank you.